Hi, I'm constitutional attorney Katherine, and I'm going to give you, for me, a relatively quick update on the hearing that happened today in Allegan County. Today, I saw freedom die a little bit more. Today, I saw the Constitution get stomped on, spit on, and burned up. I'm not talking about, some hippies at a protest somewhere. I'm talking about the behavior, the despicable, disrespectful, blatantly unconstitutional, and illegal behavior of countless Allegan County elected and appointed officials. There's not even words to put to it. I can't even go into detail about everything that happened because just telling you how many ridiculous things they did today would take me probably, well, the 3 hours I was at the courthouse today. They have no idea what the Constitution is. They have no idea what the Constitution says. I don't really think they care. They physically removed my husband from the courthouse today. After I was in my hearing, he was trying to, I didn't realize this at the time, but he had asked and wasn't given any answers on if he could record the hearing. And they didn't have a television or a viewing area that he could view what was happening. And there were no signs that he could see anything that said about not recording it. Meanwhile, I was in the courtroom all alone with the prosecutor and the judge. They denied me the opportunity to have the assistance of co-counsel. They don't even recognize me as an attorney, so they denied me having an attorney present. They denied me any ADA accommodations whatsoever. Of course, that part was off the record. They literally would not remove their masks, nor would they allow me to have an attorney present with me who can hear, and he would be able to help essentially translate for me and tell me what I was missing and be able to assist me. That was my request. That was my request for a reasonable accommodation under the Americans with Disabilities Act, not to mention our own state statutes and other federal statutes for people with disabilities. The judge outright said, basically he said he doesn't care if I have a disability. He said that he didn't ask me any information about my disability. They knew darn well I have a disability. It's written in my court file. I've seen it myself. And he said he was just going to provide a hearing assisted device. I said, that's not going to help me. That has nothing to do with my disability. If my ear is deaf, it's not going to hear. Giving me some kind of device so that I could hear more in my deaf ear is not going to help me hear any better. It's not like, the stupidity and the arrogance is just astonishing. When I said that the hearing assisted device would not help me and that having a licensed attorney who is physically next to me and there to assist me would be a reasonable accommodation, the judge just shut me down and said that he needed no witnesses present. Is this the mafia? Because that's starting to sound like it's the mafia. There's not even words. There's not even words to describe when you have someone who clearly has a disability, who cannot hear, and who is told that their disability doesn't matter, that they don't need any kind of accommodation, that I wasn't even allowed to address the court on the record with any of, I have tons of cases. I have, of course, the ADA and things like that. But I have the Supreme Court of Michigan, all the orders where they're talking about doing remote hearings, and they're talking about doing, social distancing and all those other things. They actually are acknowledging that people have disabilities, and you still have to follow the ADA. He didn't even allow me to share any of that. I was prepared for this garbage. But what I saw today, I literally saw the Constitution die a bit more today, more than we have seen it already dying. When my husband was physically removed, no one said to him, "Sir, you can't record, you need to put that away." They said to him, "You can't record, you're going to be thrown out of the building and off the property." They wouldn't even let him sit in our car because it was parked on the property of the courthouse. They made him go and stand on the side of the road. It's Michigan. That is snow. It's cold outside. Who does that? Last time they didn't even let him in the courthouse at all. Not even one step. Not even 1 foot in the courthouse. The fact that they denied me counsel, the fact that they denied me any kind of reasonable accommodation, the fact that they denied my due process rights altogether, that should tell you how the rest of the hearing went. And it went atrociously. The judge made up different things, so did the prosecutor. And they acted like the rules, some of the same rules they claim applied to me in a way that I supposedly didn't follow, which I did. They turned around and said those same rules don't apply to the prosecutor at all, so he doesn't have to follow them. What? So there's this little thing in Michigan procedure in courts. If you want to file a motion and you want to argue something about the law, you have to file a brief. So, and there's court rules about how you have to file your brief. And if you don't, then you actually are forfeiting your right to have a legal argument. They didn't file a brief. You also, if somebody files a motion for summary disposition against you, and they're saying there's no disputed facts, it's just the law that we disagree upon, then the court rule says, 2.116, says that you can, C10, says that you can file for a motion for summary disposition to have the case thrown out, dismissed, because as a matter of law, you win. Now, if you do that and you file your affidavits and everything else, then the other side, if they want to respond, then they have to file affidavits. They didn't file any affidavits. So he didn't file no evidence and no brief. So he was legally not allowed to argue any law or to argue any facts, and yet he was allowed to argue all kinds of made-up law and made-up facts. And I think he was still arguing the fact that my citation wasn't modified after it was served on me. But then the judge said, oh, it was modified, but it's okay because it is a criminal proceeding and the prosecutor can change the ticket at any time. He can amend the charges whenever he wants to. Funny thing is, it wasn't the prosecutor who amended anything. And second of all, it wasn't a criminal case. I was served with a civil infraction ticket. It had the green civil infraction strip at the bottom, the box at the top where you pick misdemeanor, civil infraction, felony, I don't know what other stuff there's on there, but it clearly had civil infraction checked, not misdemeanor. And then at the bottom, there's a box that he checked that said, I certify that I served the defendant with a copy of this civil infraction ticket, and that everything on here is true and correct to the best of my knowledge. He swore an oath to the court that he served me with that carbon copy ticket. Carbon copy. What is the point of using old carbon copy technology other than to ensure it is exactly the same as the original? Not to mention, in my brief that I have available on my website, restorefreedomkh.com, I cited several authorities that showed that when he uses those tickets, then and he modifies them after serving me, that's actually a crime. There's even one that says, I think it's the one that talks about specifically when an officer falsifies any complaint or documents like that, it's a 15-year felony, and it's grounds for being fired. But no, they think it's okay. They think it's okay. It's fine. It's totally fine. They don't have to follow the Constitution in Allegan County. No, they live in Whitmerville, and there is no Constitution there. So, yeah. So I was alone in a courtroom, not able to clearly hear. And I said on the record at one point that I couldn't even, I don't even know what the name of the prosecutor was, because it's not the prosecutor that I was originally told was on the case and was on the pleadings. It's not the prosecutor who actually filed the most recent response that follows no court rules whatsoever. It was a man, and I have no idea what his name is, because I don't need to hear. I mean, who needs to actually exercise their Sixth Amendment right to assist in their own defense, right? Or exercise their right to have the assistance of counsel, or have any kind of Fifth Amendment or 14th Amendment due process, or any kind of equal protection. Because as soon as the hearing was done, by the way, the judge made it a point, while this big, I don't know, 6'4", 300-pound guy with no name and a purple shirt standing over me as I am trying to pack up all the law, the cases, the court rules, the statutes, the constitutional provisions, everything I had on my side, everything. I came in with a big box of evidence and law because I was prepared. I knew they were going to play games. I mean, I didn't think they were actually going to spit on the Constitution so badly like that. Just totally burn it up right in front of me. I didn't think that was going to be a thing. So I was prepared. That's why I asked the attorney to come and sit with me. That is why I had all of the stuff right from the Supreme Court in our own state that says even when you're doing all this COVID crap, you still have to follow the ADA. I had stuff on open hearings because I had a feeling they were going to try to pull some shenanigans on open hearings. Did you know, everyone, here in the state of Michigan, by the way, our Constitution requires open hearings. It actually says that you have a right to a speedy and public trial in our U.S. and Michigan constitutions, but we actually are premised upon, if you do any kind of reading on public hearings at all, even back in England, there was the concept that you couldn't have a judiciary that had no oversight, no accountability. And the best way to have the accountability is to have public hearings, and it's not just a trial. The U.S. Supreme Court and the Michigan Supreme Court and like literally every other court has acknowledged that it applies to almost every kind of hearing or proceeding or trial. The only kinds of things it doesn't apply for are in situations like grand juries, that kind of thing, where there's a special reason for that. I'm not going to get into all that, but so it's a constitutional right for the people, and it's a constitutional right for the defendants. So all that aside, Michigan actually has a state law, which, by the way, has been a state law in one way, shape, or form since at least 1846. That is correct, everyone. 1846, 1846. Now, it's 2021. I've had a craptastic day, but I'm pretty sure that's like 175 years. It's been a law that every single hearing in the state of Michigan has to be open to the public. Every single one. Now, I want to say it was around, I don't know. I want to say it was when the Revised Judicature Act went into play. I want to say 1922. That's when I think they changed it. And so there's 3 exceptions. Okay, so every single hearing in the state of Michigan has to be open to the public unless, number 1, they need to sequester witnesses that are that their testimony is basically, they need to ensure that everybody's telling the truth and everything like that. They need to keep this witness separate from the other witness before they testify. Once they testify, they're no longer sequestered and they can be in the courtroom. And that's not automatic. Most witnesses are not sequestered. Number 2 is if it's, I forget the wording, but essentially a case is like a CSC case, a criminal sexual conduct or some other immorality or, something like that, where basically it's an inappropriate sexual in nature type of situation, and it's about a child. If the child is not testifying as a witness at that time, and they're a minor child, it's someone under 18, and it's one of those kinds of cases, that is the second exception. The third exception is matters of national security. Well, my hearing is a matter of national security in the sense that they just burned up the frickin' Constitution. But keeping the public out is not a matter of public security. That's a matter of public insecurity. I don't even know what to say. I mean, so there is a state law that says the hearings have to be open. And when I stated something about that, I alluded to that somewhere in my remarks, and the judge cut me off and he said, "Oh, you're wrong about that." Apparently he thinks that by doing some sort of Zoom link, that you have to have the actual link sent to you ahead of time and all that, that by viewing it through Zoom at that exact precise moment, when you're not allowed to record anything and no one can be in the courtroom with you and you have a disability and cannot fully hear everything that's going on, that is somehow a public hearing. By the way, there was a media request to be present in the courtroom or to even just record like with, their own camera equipment, or to even just tap into their feed, basically be able to record off from their recording feed. So it wasn't any additional equipment, any additional personnel involved at all. And the judge denied all of it. So the media was kept out. The public was kept out. My co-counsel was kept out. My ADA accommodation, my ADA extremely overly reasonable accommodation was kept out of the courtroom. Freedom was kept out of the courtroom. The Constitution was kept out of the courtroom. And if you were watching, if there's a way that we'll end up getting it and you'll be able to see it, I'm ashamed to say that I sounded terrified and nervous as all get out. Was I nervous about the law? No, I had the law on my side. Was I nervous about the facts? Like I thought I had done something wrong by circulating a petition on election day more than 100 feet away from the door of the polls, and I wasn't taking up a single parking space, and I wasn't harassing anyone? No, I wasn't afraid of the facts. I have 100% of the facts on my side. I have 100% of the law on my side. Even their stupid resolution, which you can't you can't arrest someone for breaking a resolution. Just so you know, that's not a thing. I actually cited all the laws and cases that clearly say if you want to enforce a local regulation, it has to be done by ordinance. An ordinance is put into place the same way that the legislature puts into place our laws, our state laws. So an ordinance is the same thing basically as a state law, but just on a local level. This is not an ordinance. They keep calling it an ordinance. It says right on it, resolution, 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 resolution. I'm pretty sure the word ordinance is nowhere on that document, but I can guarantee you that the word resolution is on there at least 5 to 10 times. And even so, it acknowledges that you can exercise your political rights, your political activities outside of the 100-foot mark. And they're trying to say that I'm saying I have a First Amendment right to park my car wherever I want to. It wasn't about my car. I wasn't even the one circulating the petitions. I came down there just to talk to him because he was threatening to arrest my petition circulator volunteers. And they specifically point blank asked him before I even got there, what if we move our car over there? Just we'll back it up. We're already on the edge of the property line. Can you show me where the property line is? We'll just move it over there. We'll talk to the neighbors. We'll get it done. And he point blank said, you can't do that. I'm not going to tell you where the property line is because you can't do that, even with the property owner's permission. What makes him think that he has the right to do this? He literally said the township property, the township hall property. It's got the township hall. It's 2 voting precincts. It's got the township library. That the outside property there at this township hall was private property. And when I said private property, who do you think the owner is? He said the township clerk. And so far, everybody in this, decision-making role in Allegan County has been okay with thinking that's how it works. I was physically assaulted by 3 grown men, 3 deputies who took an oath of office to uphold the Constitution and all constitutionally enacted laws. The Constitution does not allow 3 grown men with a badge beat up a woman and say they're going to throw her in jail and take her kid to child protection, CPS, and tow her car to the impound lot because she's there with people that are circulating a petition. What country is this? That's not the United States of America. I know most of you think of yourselves as not good enough or smart enough or educated enough to read the law. And some of you just think, I'm too busy with all this other stuff. I just can't keep up on things. Let me tell you this. Freedom died a little bit more today. My freedom died. Your freedom died. Because way too many people just stand by and let it happen. So this is my ask for you. I have 2 things I'm going to ask you to do. Number 1, I'm going to ask you to read the brief that I filed. There's a motion and a brief, and there's the exhibits. It's on the front page of my website. It's also on the documents, the resources, and then the documents tab. It's a motion for summary disposition and the brief that goes with it. Is it long? It'll take you probably a couple hours or so to read at least. Yeah. got everything in there about our freedom and what these law enforcement officials, what these judges, what these clerks, township clerks, city clerks, it doesn't matter, what every single one of these government officials is supposed to be doing and following and observing. So read that. Read that, and then read the response that came from the prosecuting attorney's office. 6 pages of garbage, totally violating the court rules on everything, on having to, have some sort of substance to support your denial. That's court rule 2.111. How about having any kind of factual counter? If you don't, then I'm pretty sure it's court rule 2.116 G4 that says I win as a matter of right. If they're not even going to bother having a response that has facts submitted through affidavits or other acceptable methods of evidence. And rule 2.119 that says if you have any kind of response on anything, or you want to file your own motion, and it talks about the law, any legal argument has to be made in a brief and supported with your cases and your statutes and whatever else that you have. They didn't do that at all. They didn't even attempt to do that. The piece of paper they submitted doesn't even have the word brief on it. So I'm going to ask you to read their piece of garbage. There's 6 pages of garbage. Then I'm going to ask you to read the reply brief. It's an actual brief that I wrote. It's 5 pages. It's more, the actual PDF is more because it has the table of contents and table of authorities and stuff, and that doesn't count in your page limit. But there's 5 pages double spaced of the content that I filed this week. My reply brief I filed this week. I ask you to read the original motion and brief. I ask you to read the response from the prosecutor, and I also ask you to read my reply brief. They're all on my website right now currently. I think my husband is also going to create a new place on the resources tab to make it easier just to see the stuff for this case alone. But either way, I'm asking you to read those. I don't care if you finished high school. I don't care if you started college and dropped out. I don't care if you have a graduate degree, but it's in art and you don't think you're qualified. If you are a United States citizen, if you are older than 13 years old, I want you to read those documents yourself, because you need to start learning this stuff. You need to start having this knowledge. We, the people, have to be educated, and we have to fight back. Otherwise, our country is gone, and our Constitution will continue to burn up until there's nothing left. People like me cannot do it all alone. I can't save the Constitution by myself. I need your help. So my ask number 1 is for you to read those documents. My second ask is whether you have $5, whether you have $500. If somebody had $5,000, I'm going to ask that you donate. And I feel terribly guilty doing this, but I'm going to ask you to donate. There's 2 links. There's a Square and a PayPal link on my on the link to this video, the description of this video. I'm going to ask that you donate because to appeal this heinous series of decisions that was made today, I'm not even given the total that I have to pay yet. I'm waiting to hear, but it's apparently going to be no less than $175 just for that filing fee. And then they're adding up. And it's, of course, at the same courthouse. So what are the chances I'm going to actually get any kind of freedom or Constitution acknowledged at all in there? This is getting ugly. So I need your help. These are out-of-pocket costs. Most of you know that I've been doing all this work on donation. I don't have another source of income coming in. I'm not taking on any kind of other cases that I used to take on. I'm a freedom fighting woman 100% of the time. So if you can, whether you can donate $5, whether you can donate 50 or 500 or 5,000, whatever it is that you can, I appreciate it. And it's going to take me a while to get some thank yous out because I still only get 4 hours of sleep at night and I'm exhausted. And I can't do this fight without you. And although I said I was only going to ask you for 2 things, one was to read those documents and the second was to donate if you can, I'm going to ask for your prayers because I'm exhausted and because I'm dumbfounded at the idiocracy, at the lunacy, at the immorality, at the blatant illegality and unconstitutionality of all of these government officials that swore an oath to uphold the Constitution. They don't care. We got to start doing it the right way. We got to follow the rule of law, or else none of this matters. None of it matters. If you knocked on doors for a candidate that you like, if you made some phone calls through an organization like AFP, if you had yard signs in your yard, if you went to the polls and you voted, if you, anything, if you've ever been a juror in a jury somewhere, if you've ever done anything related to this whole system of government we have, you could just throw it all away. It's all worth nothing if we don't stand up and fight now in a bigger way than we have ever fought before. And if any of you want to say to me, I'm too tired, or I don't have enough time, or I don't know, it's a lot of effort, or that's scary, or it's, you know, it makes me uncomfortable. What the heck do you guys think that I feel like? I'm exhausted. I haven't taken a day off in 10 solid months, not one day off. And I don't take on new clients outside of the freedom stuff. So I'm not making money. I haven't taken a paycheck through all this. Not one paycheck. I'm living on donations. I don't have time. I homeschool. I haven't had time to do laundry in an insane amount of time. I don't have people coming to help me sweep my floors or vacuum, or, you know, I don't have time, and I don't have the energy, and I don't have the money. But I love my country. I love the Constitution, and I took an oath to uphold it, no matter what. So if you love the United States of America, if you love your God-given liberties, please read those documents. Please ask your neighbor to read the Constitution. Please be invested in a way that you've never been invested before. All right, guys, I do see a ton of comments. I don't see any questions yet from Facebook or YouTube. It looks just like comments. And they look like they're in some sort of odd order because people are responding to each other and I'm not even seeing what you're saying. But if you did have a question on here and I didn't answer it, I'm really sorry. I didn't mean to ignore you. But I guarantee you'll have a ton of questions answered when you read those documents. And let's keep up this fight for freedom together. All right, guys. Have a wonderful evening.